So again, thank you everybody for joining us. I'll introduce myself, I guess, add on to Jeff. So my name is Taylor Nielsen. I'm with the business development team at Rizzetta Company. Rizzetta Company is a full-service community management firm servicing small to large associations, commercial and residential, throughout the state of Florida. We've got 8 offices throughout the state. So if you have any community needs, we'd love to help you elevate your community's potential there. With us today, our guest speakers that are important folks: Kerstin Henze, attorney at K. Bender Rembaum, and Frank Valdes of GetQuorum. These are going to be our speakers today, so I want to give them our appreciation for joining us today. In today's speaker series, we're going to talk about elections, as mentioned, and also the ever so popular topic of e-voting that is becoming very popular with our technology nowadays. So before we start, thank you again for Jeff for going through the Q&A component and how that'll function. And with that, I'll turn over to Kerstin to get us started. Kerstin.
Great. Thank you, Taylor. Hello, everyone. Again, I'm Kerstin Henze. I'm one of the attorneys with the law firm of K. Bender Rembaum. For those of you who are not familiar with the firm, we are an exclusive community association law firm. So that means that we represent exclusively condominium, HOAs, and cooperative associations throughout the state of Florida. We do have our main office located in South Florida in Pompano Beach. But we also have other locations. So we have locations in Palm Beach Gardens, in the Orlando area, and then I manage the West Coast office for the firm, which is located in Tampa. So if you are looking for legal services, depending on where you are, just contact the office that is physically closest to you. All right. With that said, let me pull up the slides for today. You will be getting these slides at the end. Give it a minute here. All right, can everyone see it? Yep.
Yes.
Okay, good. All right. All right. So let's talk about annual meetings. We'll talk about annual meetings for condominiums first, and then we'll switch over to HOAs. I'll try to minimize this bar a little. All right. In terms of number of directors, well, the statute says that unless otherwise provided in your governing documents, a board has to consist of 5 members, except if the condominium has 5 or fewer units, in which case the board consists of at least 3 members. Essentially, take a look at your bylaws. The bylaws is the document that is going to address how many directors are on the board. Simultaneously, you might have to take a look at your articles of incorporation. The articles and the bylaws are your 2 documents that basically set out the corporate structure of the condominium association. And so you want to always take a look at the articles to make sure there is no conflict with the bylaws. In my experience, typically, the articles will just provide the minimum number of directors, but may not necessarily set the maximum number of directors, or it might just set the range. And then the bylaws will likely set the exact number of directors that should be on the board. So just take a peek at both. Now, determining the number of directors at the election is not a valid method for determining the number of board members. So what that means is that you need to know in advance how many directors need to be on the board and how many directors can run for your election. So on the date of the annual meeting, that is not the date at which you're going to be determining how many directors will be serving on the board. This has to be done in advance. And if you want to modify the size of the board, whether it's to increase or reduce the size of the board, you have to take a look at your bylaws to see how you can change the size of the board. It may be that you need to amend the bylaws. It may be that it's completely a business decision of the board. So take a look at those documents. Okay. Did I skip over one? I'm sorry, folks. Okay. Terms of directors. The terms of all board members will expire at the annual meeting. And members may stand for re-election unless, of course, you have staggered terms, or if all directors' terms would otherwise expire, but there are no candidates. Okay, and sometimes that's just the case. Nobody sends a notice of intent to run. Okay, in which case the board members roll over unless they decide to resign. Now, if permitted by the bylaws or the articles, board members can serve a term that's longer than 1 year. Now, the law changed several years ago to now clarify that as of July 1st of 2018, condominium board member cannot serve more than 8 consecutive years unless approved by 2/3 of the members voting, or there are not enough persons who are willing to serve. Okay, so 8-year consecutive terms, and that time clock started July 1st of 2018. Of course, if the number of vacancies equals or exceeds the number of candidates, then there is no election and directors will be seated on the date of the annual meeting by acclamation. Board member eligibility. Well, the governing documents can require board members to be owners. Now, there's a misconception that Florida law, Florida statute requires directors to be owners. That is not the case. That qualification requirement is something that would be specifically set forth in your articles or bylaws. Okay. Now, pursuant to Chapter 617 of the Florida statute, and again, Chapter 617 is the chapter that governs not-for-profit corporations in the state of Florida. So while your association is a condominium association governed under Chapter 718, it is also a corporation not-for-profit. And so Chapter 617 will also apply. And what that chapter basically says is that if the unit is owned by a trust, then the grantor of the trust, the individual that sets up the trust, or the beneficiaries who reside in the unit are also eligible as unit owners and then can run for the board. Okay. Other eligibility requirements for board members that you might have in your governing documents might not be valid. And we'll talk about other statutory qualifications in a minute. Now, the law changed in 2021 to now provide that any person who is delinquent in the payment of assessments due to the association is not eligible to be a candidate. Now, the law used to say that if you were delinquent in any monetary obligation to the association, you were not qualified to run for the board. That's no longer the case. So if the candidate is delinquent on attorney's fees or interest or late fees or even fines, those monetary obligations would not qualify. Would not count towards the disqualification. It has to be only a delinquency on assessments. Other eligibility requirements set forth in the statute are that a person who has been convicted of a felony, they're not eligible to run for the board unless their civil rights have been restored for the last 5 years. In a residential condominium association, if you have more than 10 units, co-owners of a unit also cannot serve as members of the board at the same time, unless, of course, they own more than 1 unit or unless there are not enough eligible candidates. And then there's also that the requirement that board members cannot serve more than 8 consecutive years, which we discussed a few slides ago. Now, a candidate is any person it's an eligible person who has timely submitted written notice of intent to run. So under the statute, under Chapter 718 of the Florida statute, if you want to be a candidate for board membership, then you have to be eligible by the time that you submit your notice of intent to run. And we'll talk about in a few slides when you need to submit your notice of intent to run, but essentially at least 40 days prior to the date of the annual election meeting. Okay, that's when all your accounts need to be brought up, paid up. as well as you have to meet all other eligibility requirements. Now, what happens if a board member who's not qualified makes it onto the election ballot? Well, the Florida Administrative Code says that if a ballot includes a name of an ineligible candidate, then the association has to provide an amended second notice to the members, explaining the reason why you're sending out an amended second notice. Now, that amended second notice, we'll talk in a few minutes, has to be provided to owners at least 14 days prior to the annual election meeting. So if you don't have enough time to provide an amended second notice to address this, the ineligible candidates on the ballot, then the administrative code says that you have to then essentially renotice your entire election. Start from the first notice. Okay. If the election has occurred in which you provided a ballot with an ineligible candidate, then the administrative code says the election is deemed void and the association must renotice the entire election. It also subjects your election to a successful legal challenge if any owner were to challenge the election. All right, let's talk about notices. So there's two main notices that go with a condominium election, as many of you may be aware. We are going into election season. So the first notice is what it's called, the first notice of your annual election meeting. And that has to be provided to the membership at least 60 days prior to the scheduled election. Now, it can be either mailed, hand-delivered, or electronically transmitted to those owners who have consented to receiving notices electronically via email. Now, any individual who qualifies and wishes to run for the board of directors has to provide what is known as a notice of intent to run. And that has to be submitted no less than 40 days before the scheduled election. Now, as a practical tip, there's nothing in the statute or administrative code that provides a specific form of what that notice of intent to run has to look like. So essentially, a director that wants to run for the board can literally put their notice of intent to run on a napkin or post it and send it to the association, okay? That would be sufficient. Now, a candidate also has the ability to submit what is known as an information sheet. Essentially, it's the individual's bio, why they qualify for the board, their experience, and why they would be an effective director. So if the candidate wishes to submit an information sheet, that has to be on a paper that is 8.5 by 11, and it has to be furnished to the association no less than 35 days before the election. Okay. If you, the association, if you receive this information sheet from a candidate, you will have to enclose it with your second notice. So the second notice of your annual election meeting has to be sent to the members at least 14 days prior to the election meeting. And that second notice of election will also include the election ballot, okay, listing all the eligible candidates by surname. It will also include the information sheet if the candidate timely provided that information sheet. It will also include a proxy if, in fact, you have other agenda items for that meeting. And we'll talk about quorum and the use of proxies, but you would only need to use the proxy if there are other agenda items that you wish to discuss. So you would include that with your second notice. You might also include a voting certificate. If your bylaws require voting certificates and the board has enforced voting certificates in the past. And a voting certificate essentially is a document that your bylaws would require you to send it to the owners in the event that a unit is either owned by multiple individuals or a unit is owned by an entity. And so in those cases, the owners of the unit would identify who among themselves or who would be the authorized officer or corporate representative of the entity that it would be entitled to cast the vote for the unit. So you collect those voting certificates, and then on the date of the annual meeting or any other membership at which owners get to vote, you would compare the voting member against your voting certificate. Okay, but that's only if you enforce voting certificates and your documents require it. The second notice of the annual meeting also has to be posted on condominium property at least 14 days prior to the meeting. Now, for website requirements, in addition to providing the notice, the first and second notice of the annual meeting, whether it's by mail, hand delivery, or electronically, you also have an obligation to post those notices on association website. Now, the current requirements remains that only condominium associations with 150 units are required to have a website. But that requirement is going to change come January 1st of 2026. Come January 1st, the obligation to maintain a website will apply to any association that has at least 25 units or more. Okay, so just be aware of that. If you fall in this website requirement category, be sure to post notice of the meeting at least 14 days prior. And then you're also required to post on your website any document that will be considered and voted on by the owners. So if you have other agenda items set for this annual meeting, for example, if owners are going to be required or requested to vote on amendments. So you're going to want to post a copy of the amendments, a copy of the ballot, a copy of the proxy, and that's assuming you don't have electronic voting. Electronic notices. Now, remember, I've been saying that you can provide notice to the owners either by mail, hand delivery, or electronically. Just caveat, you would only provide notice electronically to those owners who have consented to receiving notices in writing. So you need to have some form of written consent, and it can be done by email, but some documentation confirming that the owner has consented to receiving notices by email. If you don't have that consent, then just emailing these official notices to the owner would not qualify as the official notice to owners. You would have to then send it either by mail or hand delivery, and then as a courtesy by email, okay? This is not to be confused with electronic voting, which Frank will talk about momentarily, okay? This is simply dissemination of the notices to the members via email. All right, quorum requirements for your annual election meeting. So there is no membership quorum requirement in order to conduct the election part of your annual meeting. The only thing that the statute requires and has for, as far as I can remember, is that at least 20% of the eligible voters have to cast a ballot in order to have a valid election. So as long as you receive election ballots from at least 20% of your membership, you can continue with your election portion of the meeting. Now, be aware, House Bill 913 that just took effect July 1st now has a provision in the statute that says that if the annual meeting is conducted via video conference, a quorum of the board must be physically present at the physical location where unit owners can attend the annual meeting. Now, in the next few slides, we'll define what video conference is, but essentially your typical Zoom meeting would qualify as a video conference. So the statute now expressly allows board and membership meetings to be conducted via video conference. And if you are conducting your annual election meeting via video conference, the statute now says that a quorum of the board has to be physically present at the physical location. Now, the statute doesn't really say what happens if a quorum of the board is not present at the physical location, right? Again, quorum has never been a requirement to establish an election. And so I think a reasonable position can still be taken, that as long as you receive 20% of the election ballots, you can still pursue your election. Quorum of the board has also never been required for a membership meeting. Typically, yes, a quorum of the board is present and presides over the membership meeting, but a quorum of the board in and of itself has never been a requirement for a membership meeting. And so I think a reasonable position can also be taken that if a quorum of the board is not present at the physical location, the membership meeting can proceed. And that's, again, assuming if you even have any other agenda items set for your annual meeting. Now, proxies cannot be used in elections. You can only use ballots for purposes of electing directors. Other changes that took effect July 1st in House Bill 913 include if your bylaws do not provide the location of your annual meeting, then the annual meeting has to be held within 15 miles of the condominium property or within the same county as the condominium property. It used to say within 45 miles of the condominium property. Now it's within 15. The statute also provides that unit owner meetings, including annual meeting, can now be conducted in person as well as via video conference. If you are conducting your annual meeting via video conference, then these are the following requirements that have to be met. Your notice needs to include a hyperlink and call-in conference phone number for the unit owners to attend the meeting. And then the notice has to include a physical location where owners can still attend in person. Okay, so that physical location part is now expressly set forth in the statute. You can give owners the option to attend the meeting electronically, but you have to have a physical location if you're going to have the virtual part. And then note that video conference has to be recorded. So you have to record your Zoom meetings, and those recordings are now required to be maintained as part of the official records. Okay. So if you don't want to have to record these virtual meetings and you don't want to have to go through the hassle of maintaining those recordings as part of your official records, then don't conduct these meetings virtually. Okay. And the statute also defines what a video conference is, which is the bullet point here at the bottom. It is defined to mean a real-time audio and video-based meeting between two or more people in different locations using video-enabled and audio-enabled devices. All right, so you've now provided all these notices to the membership of your annual meeting. You've now been receiving all these election ballots. What do you do next? Well, those election ballots have to be verified, right? And the election ballots, if you recall, or those who are not aware, they have to have on the exterior of the envelope blank spaces for the owners to identify their unit number, as well as for them to sign the outer envelope, right? And so now you need to verify those envelopes. There's two ways that you can verify the outer envelopes. One way to verify outer envelopes is at an impartial committee meeting that you can conduct in advance of your annual election meeting. And then the second option would be to just simply verify these outer envelopes on the date of your annual meeting. So if you choose to go with the verification prior to your annual meeting, and many associations do that just to, not to spend so much time on the date of the annual election meeting verifying these outer envelopes, right? Especially if you're in a condominium with, several hundred owners. So the meeting has to be conducted by an impartial committee of individuals, of members who are not current directors, who are not officers, and who are not candidates for the board or any of their spouses. So if you can get that committee together, simply notice this meeting like you would any other board meeting with 48-hour advance notice. And then on the date of the meeting, owners are allowed to come in and basically watch you verify outer envelopes. And you would essentially be looking at the name of the outer envelope and then comparing it with your unit roster. And if you have voting certificates and enforce them, then you would be also comparing them against the voting certificates to make sure that only the authorized voting member has signed the outer election ballot. If you choose to do the outer envelope verification on the date of the annual meeting, then after you call the meeting to order, that's typically one of the first things you will do, okay, before you proceed with anything else on the agenda. Now, keep in mind, once the election ballot is received, it cannot be rescinded or changed. Once you have verified the outer envelopes, then you will go into the process of opening the ballots and counting the ballots. So essentially, you would slice through the outer envelope, take out the inner envelope out. Once all the volunteers are done doing so, then you will, slice through the inner envelope, take out the ballot, and then you will start the counting. Important to note that the election polls remain open until the first outer envelope is sliced open, or until you start accessing the electronic votes, whichever occurs first. So until that point, if you're just verifying outer envelopes and an owner comes in, with their election ballot, you can and must still accept that election ballot. Okay, until you slice through the outer envelope. Runoff elections rarely happen, but they could. So if two or more candidates for the same position receive the same number of votes, which would result in one or more candidates not serving or serving a lesser period of time, then the association, unless otherwise provided in the bylaws, have to conduct a runoff election. Okay, so typically if I am chairing the election and assisting with the election process and this situation arises, I would ask the candidates to see if any one of them would voluntarily step down. And if they don't, then absent something to the contrary in the bylaws, you'd proceed with a runoff election. The Florida Administrative Code is the code that outlines the process for a runoff election. And essentially, the runoff election has to be held no less than 21 days, no more than 30 days after the date of the election. And then within 7 days of the date of the election on which the tie vote occurred, the board has to mail or personally deliver to the voters a notice of the runoff election. And on that runoff election ballot, you would only identify the two candidates that are subject to the election. Okay. Frank is going to talk about in a few minutes about electronic voting, but I do want to point out this electronic ballot, which came into effect July 1st of this year. Again, this was part of House Bill 913. And the statute now provides that unless the association has adopted electronic voting, so if you do not have electronic voting, then the association must designate an email address for receiving these electronically transmitted ballots. Now, an owner may electronically transmit a ballot to this email address that's designated by the association without complying with the statute or rules concerning the secrecy of ballots. So if an owner doesn't want to maintain secrecy of how he or she votes for the election, then this is an option going forward. The owner has to transmit his or her completed ballot to the email address designated by the association no later than the scheduled date and time for the meeting. Now, the association has to count the completed ballot that was electronically transmitted if the ballot includes the following. So the ballot has to include a space for the owner to type his or her unit number, a space for the owner to type his or her last name, which can function as a signature. And then the ballot has to include the language here that's in boldface, okay? So waiving the secrecy of your ballot is your choice. You do not have to waive the secrecy of your ballot in order to vote by transmitting your completed ballot through email to the association. You waive the secrecy of your completed ballot. So essentially, it's just a big disclaimer saying if you want to waive the secrecy of your ballot, this is an option by which you can now vote. Okay. All right, let's quickly go to HOAs, annual meetings for HOAs. The governing documents may require board members to be lot owners, and there are no maximum term limits in the statute. If you are convicted of a felony, you cannot serve on the board unless your civil rights have been restored. Unlike the condominium, for condominiums, any person who is delinquent in the payment of any monetary obligation is not eligible to be a candidate. So if you are delinquent on fines or attorney's fees, interest, late fees, whatnot, those will count towards your qualification. Pending charges of felony theft or embezzlement offense involving association funds will disqualify you. And unlike condominiums, co-owners are permitted to be candidates and serve on the board. No other eligibility requirements will be valid. With HOAs, the association has to hold a meeting of its members annually, and typically it is at that annual meeting that you will conduct your election. Your notice obviously has to include the date, time, location of the meeting. And then unless your bylaws provide for other notice, you are required to either mail, deliver, electronically transmit notice of your annual meeting at least 14 days prior to the meeting. Okay. And again, you would only email the notice of your annual meeting to those owners who have consented in writing to receiving notices electronically. The big takeaway with HOA elections is that elections of directors for HOAs have to be conducted in accordance with the procedures set forth in your governing documents, and those would be outlined in your bylaws. So unlike condominium associations who have to follow this statutory process with the first and the second notice and whatnot, HOAs are strictly for HOAs, you have to follow the election process that's strictly set forth in your bylaws. Okay. So, I'm aware that many associations over the years have decided to adopt, for example, an election process that is very similar to condominium associations with the first and the second notice. Again, if that is how you want to run your elections, that's fine. Just make sure that you amend your bylaws to provide for that process. Adopting this process by rule or policy or resolution is not enough. It has to be in your governing documents, okay? Now, as of July 1st of 2013, if the election process that's set forth in your governing documents allows candidates to be nominated in advance of the meeting, then you're not required to have nominations from the floor on the date of the meeting, okay? But again, that's only if your documents allow for nominations in advance, such as by these notices of intent to run. Otherwise, you have to have nominations from the floor on the date of your annual election meeting. With HOAs, unlike condominiums, you have to establish quorum in order to proceed with your annual election meeting. Okay, so that is really your first agenda item. You have to establish quorum. And quorum for your HOA, unless you have a lower number set forth in your bylaws, quorum is going to consist of 30% of your membership. Okay, so take a look at what your bylaws provide. If you want to lower the quorum requirement from 30%, that would typically require an amendment. Unless your documents say otherwise, typically members have the right to vote at the election either in person or by proxy. So if you don't want owners to vote by proxy at your election, you want to allow them to vote or require them to vote by secret ballot, like the ones that are used by condominiums, then you're going to have to amend your bylaws to specifically say that, okay? The statute does say that if the governing documents permit voting by secret ballot, for those who are not in attendance, then you essentially have to use this condo style election ballot. You're going to have that outer envelope, and then you're going to have that inner envelope. All right, vacancies. Unless otherwise provided in your bylaws, any vacancy occurring on the board before the expiration of the term may be filled by the affirmative vote of the majority of the remaining directors, even if the remaining directors constitute less than a quorum. So what that means is if you have a board of 5 directors and everybody decides to resign and there's one single director left, that single director has the ability to fill the vacant seat. Okay. In fact, the one and only thing that that single director can do is fill enough seats to constitute a quorum on the board so that then business can be conducted. In the alternative, the board can hold an election to fill the vacancy. Election of officers. So generally, officers will be selected by the board immediately following the election at a meeting that's called organizational meeting. So typically that organizational meeting will immediately follow the adjournment of the annual meeting, or you can set that organizational meeting for a few days after the annual meeting. Now, directors typically cannot vote by proxy or by secret ballot at board meetings, with the exception that they can vote by secret ballot for the election of officers, okay? And there is no prohibition against changing officers midstream. And so if in the middle of the term you see that any particular officer is not doing what they're supposed to, the board can have a meeting to reorganize. All right, and then in the interests of time, I'm not specifically going to go through all the board certification requirements, but I have included the slides here. Specifically, I just kind of want to highlight for condominiums, you have to do now 2 things, okay? You have to provide a written certification attesting that you have read your governing documents and will, to the best of your ability, uphold them. And you also have to attend that 4-hour division-approved board certification class, okay? So it's no longer that you can do one or the other, you have to do both. If you're a newly elected director, you have to do both within 90 days of being elected. And if you were elected to the board before July 1st of 2024, you were supposed to have completed both of these requirements by June 30th of 2025. So the deadline just passed, okay? So if you haven't yet taken your 4-hour board certification course, please do so right away. Otherwise, you are deemed suspended from the board. With HOAs, the new requirement is that the director has to complete the board certification class within 90 days of being elected or appointed, okay? And that certification class has to be completed every 4 years, okay? Now, in addition to that, you have continuing education requirements, and the number of hours that you need to log in will depend on the size of your community. So if your community has less than 2,500 parcels, you have to do an additional 4 hours of continuing education every year. Otherwise, if your community has more than 2,500 parcels, you are required to do 8 hours. All right, you can look at these slides in a little bit more detail once you get them. And last slide for election disputes, just know that any challenge to the election process has to be commenced within 60 days after the election results are announced. And typically election results are announced on the date of the annual meeting. So you have a very small window to challenge elections, 60 days. The election can be challenged either through a petition of arbitration with the Division of Condominium or through the circuit court. Okay, and this applies to condos and HOAs. All right, I'm going to pass on the baton to Frank, and he's going to talk about electronic voting.
Thank you so much, Kerstin. That was great. That was a lot, folks, for you on the call that are trying to get more information. Obviously, Kirsten's contact information just popped up. That'll be available to you, and so will mine. So don't panic. I see the questions bubbling up, so I'll let Kirsten get to those as I'm giving my portion of this. So do not fear. You've got subject matter experts here to assist. So hopefully everybody's seeing my slideshow, and let's get into some electronic voting. There may be a few items, such as the House Bill 913, items that came out of that may sound repetitive, but they won't. I'll make sure that we all have a good understanding of e-voting as a whole. And again, don't panic, everyone. I'm available after the call today, right? Whether it's a question, comment, concern, I'll post my information there as well in this video, and slides will be available, made available to you. So I'm Frank Valdes. I'm the regional director in the state of Florida for GetQuorum, state certified with the DBPR to teach my own e-voting courses, served as a board member in my HOA, and prior to this role that I've been at 4 years, worked in the property management industry. I represent GetQuorum. We provide electronic voting to north of 3,000 associations and over 30 experts over here, but it's a fully managed electronic voting service that we provide for the most part, and we've got integrations all throughout these different platforms. So let's jump right in as to why we're perhaps even discussing electronic voting. So beyond the elections, and of course, that would be an absolutely fantastic way to introduce electronic voting for the community. There are other areas where you can use e-voting, but certainly as it pertains to elections, whether it's our condos, co-ops, or HOAs, electronic voting is and will continue to be used at a very high level. And I'll walk you through some of the statutory requirements. So, right, that'll be one of your big takeaways in our call today, to make sure that you have an understanding today as to how to enact that electronic voting process in your community. But I do want to point out that there are other areas where electronic votes can be just as useful. Those include special assessments. Those include waivers of non-source funding. There's again so many things. Adoption of amendments to your bylaws, declaration amendments. So keep that in mind as you even dive into the world of electronic voting. Good news today. The number of condos and HOAs in Florida that are leveraging the electronic voting is north of 32%, probably closer to 40% in the state of Florida. There's quite a few associations, as you can imagine. So legislation, believe it or not, was enacted back in 2015. So ladies and gentlemen, we're 10 years in, 10-year anniversary here of electronic voting being allowed in the state of Florida for associations. Again, our condos, co-ops, and HOAs back in 2015. We kind of put that in park for a while. We wanted to make sure, I think for the most part, it was working. And then there's a massive sense of comfort now with associations. And obviously the House Bill 913 is certainly creating a nudge. Good news coming out of what we've seen in our case studies is that participation rates jump from 20 to 80% on average with electronic voting. That includes 55 and better communities. So for those folks on the call today wondering, well, will this work in my community? We may or may not have some elderly population. They may or may not be great with electronics. It does, and it will work. Again, just to position the beginning of electronic voting, and when you have to make sure that you establish in any community, whether you're a condo, co-op, or HOA on today's call, I want to make sure that you understand that there are some statutory requirements or boxes to check, if you want to call it that, which are required to be followed by all of these associations. They include a resolution being passed by a board member vote only. So I'm going to repeat that. It is a board member vote only. It is not a membership vote. And there is a resolution requirement. So resolution, I should say, by the board of directors adopted, allowing for e-voting to be used. That's kind of the on switch. That's all that is. Now that resolution does come with a notice requirement. That notice requirement was changed for our condos with that House Bill 913 to a regular board meeting requirement. All right, so just to walk you through that, board notice goes out, agenda item states, adoption of a resolution to allow electronic voting, right? And then of course you've got a board meeting where the board is voting on a resolution to allow electronic voting. Now, the notice requirement is still the same for our co-ops and our HOAs. Just to be very crystal clear here, it is a 14-day notice. We expect that to be updated in the future. But if you're an HOA or a co-op on the call today, you do have a 14-day notice requirement in order to have the meeting where the board is still going to be voting on that resolution to allow electronic voting. All right, so 14 days, condos, co-ops, regular, normal board meeting notice, 48-hour notice for our condos on the call. You get that out of the way, and definitely please consult your association attorney in relation to obviously passing or getting that resolution even drafted. But you get that out of the way, and you kind of move on to step number 2, which is getting owners to consent to electronic voting. That is a requirement in the state of Florida. Just to be very clear on today's call as well, is that owners must consent to electronic voting. If they do not consent to electronic voting, if there isn't an official consent form on file, whether it is written or an electronically signed consent form, an owner cannot cast an electronic vote as it pertains to e-voting, at least with a platform. Now, Kerstin mentioned another option earlier for our condos, and I'll review that, kind of an email sort of vote. But for the most part, using an electronic voting platform does require an owner to consent to electronic voting. With that consent, and it only has to be done once, good news, right? Owners do not have to consent or opt in every single year. They do stay opted in perpetuity. But with those documents on hand, which are official association records, then electronic votes can be cast by owners moving forward. So for the most part, those are the steps, right? Good news, electronic votes count towards quorum, right? An e-vote that is cast, pursuant to the provisions in the e-voting statute does count the member or the owner towards your quorum requirements. That goes a massive long way, not only for some of these annual meetings, but more importantly for things like special meetings, where you have usually a high threshold of owners that you need participation from. Again, I'm going to emphasize this and letting you know that you've got to comply with the electronic voting statutes. Good news for you today. I've outlined them. I have outlined them there. There's 718.128, 719.129, and 720.317 right in front of you, all good to go for you to review. Few updates came through that House Bill 913 to electronic voting specific to condominiums. So I know that those on the chat and kind of the questions, I should say, have thrown up questions saying, hey, does this pertain to condos or co-ops? Well, this specific section that I'm reviewing right now is unique to our condos. And we do expect in the future some of these provisions to be extended to HOAs. But as of right now, for the folks on the call, we are speaking to you of your condominium association. The 14-day requirement, as I mentioned earlier, that changed for the resolution to 48 hours. Here's another one. Here's a big one too. If 25% of the unit owners petition the board to adopt electronic voting in the association within 180 days of the last annual meeting, then the board must hold a meeting within 21 days after the receipt of that petition to adopt electronic voting. All right. So it's basically a call to action by way of a petition from owners to ask the board to provide an electronic voting alternative, at least professionally speaking. That's new. That wasn't around for condos before July of this year. And again, make sure that you understand that that does trigger the beginning of this process, which is a resolution to be passed. Some of these items were mentioned by Kerstin earlier, including official records now include recordings of meetings, right? Video conferences, Zooms. If you're basically a condo out there and you're using some sort of video conferencing option for your owners, make sure that you have a recording and that is around for a year, right? So that is a provision there. Keep in mind, I've got associations that we work with that are north of 8,000 doors. So I understand that there are some cases here where video conference absolutely makes sense, right? Condominium associations that are 800 doors where, conferencing is used. Absolutely, right? You may not have a room big enough for 800 owners to show up in the event that you only wanted to have an in-person option. So it may make sense. Just make sure you're recording that. And again, in terms of some of the other provisions here, so we'll move it along. Here we go. All right. So House Bill 913, again, if the annual membership is held electronically, then a quorum of the board. Kerstin walked through that. She also walked through the fact that if the association has adopted electronic voting, then this doesn't apply to you, where you've got to set up an email address to allow owners to send in their secret ballots, so to speak, which then foregoes the secrecy of that ballot. In the event that you already have an electronic voting provider, that specific provision won't apply to you. So you have e-voting in place, you're good to go. If you don't, and you're a condo, you've got to set up an email address and give owners an option to email a ballot in. All right. So let me walk you through some of those best practices that we do want moving forward. Please, please, I implore you, consult and involve your legal counsel in this process of implementing electronic voting. In an ideal world, there's kind of the dream team here, right? As they call it, Avengers are assembling, and it's electronic voting provider, property management, certainly the current board, and legal counsel. Make sure everyone's on the same page as to the process of electronic voting, who your provider is, and how it's going to roll out more importantly. Make sure that you're accounting for your pre-existing bylaws, right? Communicate with owners once you've enacted electronic voting to make sure they understand the shift in service and in options. Choose a suitable platform. I can't emphasize that enough. That is unique and takes care of the challenges for your community. There's condos out there that have a normal, regular election, and then there's HOAs that we've worked with that have nominations from the floor and voting the day of. E-voting is available for all shapes and sizes here. Just make sure you choose the right platform that helps you. In terms of your meeting format, make sure you're designing and adjusting for that meeting format, right? Again, there are some challenges, changes, nuances with e-voting. Whole dress rehearsal, if you're going to use a virtual meeting platform, e-voting, all of that stuff, make sure everything's up and running and working and it's been kind of tested. And again, make sure that from a technical support standpoint, you have all of the help that you need. Be overly prepared if possible, not only board members, but also owners and legal counsel as well. All right, so I'll leave it there. I know that was a short, very quick summary of electronic voting in the state of Florida. Participation rates are north of 80% on year one. I see some questions bubbling up there on the Q&A, so I'll leave some time open for that. And again, we'll make ourselves available. At least I will here with my contact information should you wish to reach out for a more specific conversation about your needs.
Thank you, Frank. I appreciate it. And thank you, Kerstin. So I want to jump right into Q&A here while we've got a couple minutes left. I have seen a couple questions that have come, in various verbiage from multiple people here on the call. So I'll start with those as kind of priority. But one of those was in regard to the 8-year consecutive term limit. Does that apply to HOA board members as well as condo? And, if that term limit hits mid-term that they're serving, do they finish their term, or how does that apply? I'll direct
Well,
that.
the good thing is it doesn't yet apply to HOA board members. So this is strictly to condominiums. Yeah, the law for condos is a little bit unclear as to how this is really going to play out, practically speaking. So at the moment, there is really no guidance from the division. So I kind of want to refrain from guessing how this would play out, and let's see what happens.
Okay. The second one that was really very much reoccurring here as a theme was the felonies aspect and the background checks, right? So do you have recommendation on how the boards should go through that process of background check or screening for felonies and verifying that those people are qualified to be serving on the board?
Yeah, I mean, unfortunately, the statute doesn't really provide much guidance on that, other than tell you that you would not be qualified if you have these convictions. So I would say probably the best practice is for the board to adopt a resolution to require the board member to consent to a background check. Typically, if you're already in a community that screens buyers, right? Those who are looking to purchase units in the condominium, if you already have a process in the declaration that allows the board to screen these applicants, then hopefully you would have already screened them and you have something in your records. But otherwise, I would say adopt a resolution to require this.
That's excellent advice. I've been part of the meetings, so thank you for that, Kerstin. HOAs, right, as well, and condos, because I've been part of meetings where nominations from the floor, board member gets selected. Week later, someone finds out that they're convicted felon and don't belong on the board, right? So absolutely a process in advance, as Kerstin just mentioned, including a resolution, probably works a lot better than the week after.
Right. And then there's another question too that I think it's valid. what are the options if no owners want to be on the board?
That's a problem.
Yeah.
And unfortunately, it's becoming a very common problem, just simply because of all these additional constraints and obligations on board members.
Yeah.
You want to have at least a quorum of the board seated. If you have a requirement to have a large number of directors, by that I mean 7 to 9 plus directors, then you could also potentially consider reducing the size of the board. And how you reduce the size of the board will depend on what your bylaws say. Does it require an amendment? Is it up to the discretion of the board? I typically like to suggest that if the board is going to amend the bylaws, give the board the option to increase or reduce the size of the board as the board deems it appropriate, right? Because circumstances change, conditions change, right? And so if you have to amend the bylaws every time, I mean, that's an impossible task for many communities. So that's another option, change the size of the board. And then, I mean, the last resort, which you don't want to be in, is receivership. That is ultimately what's going to happen if you don't have enough owners who are willing to step up and serve on the board, at least a quorum of the board. You could subject your community to a receivership situation where a judge appoints a third party to basically run the business of the association until you can get a quorum of the board. And that can be a very costly process.
Just want to add to what Kerstin said, and that's an excellent question, Carla. On the side of electronic voting, certainly we're doing our part as a provider. There is an electronic candidacy form that can be filled out. I think that rings true and opens up the possibilities of maybe more owners, receiving information, participating, and being engaged, right? So don't discount electronic communication, electronic options for owners to provide a candidacy form that might otherwise not be opening a mailbox. Keep that in mind because you will increase the pool, right, of owners at least receiving this information and perhaps not have issues with participation.
That's correct. And then also, that's an annual meeting count if it was not officially called to order.
I'll let Kerstin answer that one.
Kerstin is like,
does an annual meeting officially count if it wasn't called to order because there's a lack of quorum?
Yeah, probably. It didn't explain.
Or if they
Right.
just didn't call it to order, right? If
Or
they just
or they
ripping
just
off.
didn't call it to order.
Yeah.
They just kind of rolled over, probably.
Well, I mean, again, if you have the 20% if 20% of the membership submit an election ballot, you can proceed with your election portion of the annual meeting, and your minutes would reflect that. If you don't have a quorum and therefore you couldn't call the meeting to order for all these other agenda items, then your minutes would just reflect that.
Okay. So
and there's
basically,
no obligation to then, recess and, until you get a quorum for the annual meeting. That was the one shot.
Mm-hmm.
I see one here on e-voting quickly here. It says, how do we handle changes in owner information, right? Perhaps as an owner changes a unit or sells a unit, make sure that you connect with an electronic voting platform that has direct access to your owner information, so that they have the latest and greatest updates. And that is an independent platform, regardless of what management program or software you're running in the back end. You certainly can have the electronic voting information up to date. So thank you for that.
Thanks, Frank. So that runs us just over 1 o'clock here. So I apologize. We weren't able to get to all the questions, but I think we did get a good bit of them. Again, there's a lot of reoccurring ones there and specific themes. So I want to, make sure we wrap up here at least close to on time. And thank you so much, Kerstin and Frank, for being here, a part of this and educating the audience. If anybody needs to refer to this and look at the slides, we will be posting it on our YouTube channel. You can find that probably in about 48 hours after we're able to edit everything and get it published. Our YouTube link is on our website, Rizzetta.com. And thank you again so much, Kerstin, Frank, and everybody for attending today. I hope you were able to take away something valuable today. So thank you.